Welcome to the Emerging Civil War podcast. I'm Chris Mikowski, and joining me today is my colleague, one of our new fresh faces
Mhm.
at ECW, Kevin Donovan. Kevin, hello, how are you?
I am doing great. Glad to be here, Chris.
It is a pleasure to have you with us, and I think you're a great example of an emerging voice in the field. I called you a fresh face. People might look at you and say, he might not look quite so fresh, but fresh face in the field for certain.
Exactly. I'm sitting here. I've got my Medicare cards and information to look at, so everything's relative, but I'm fresh to emerging Civil War.
But I think it's wonderful. You describe yourself as a recovering lawyer, and so sort of redefining yourself in this stage of your life as a Civil War historian. Tell us a little bit about how you got where you're at.
Um, what in terms of Civil War interest or
Yeah,
law? Both?
yeah, it's in Civil War interest. Tell us your Civil War origin story.
Okay. Well, it's really, I guess, two-part. My father, who had a career as an accountant, he always wanted to be a history teacher. That was always his goal, but I guess there was not money in it. He comes out of World War II. He goes to college on the GI Bill, but he always had a very deep interest in history that, he put into me. I have a vague memory, and I had to go back to the web to make sure this wasn't a dream, of as a very young child being on what turned out to be Henry House Hill, looking at this huge statue, and I thought that's got to be Stonewall Jackson. And am I dreaming? And I said, no. I looked it up, and there is a statue of Jackson on Henry House Hill. So that is probably my first Civil War related memory. And
That's
then,
actually the birthplace of my Civil War career as well. So look at that, great company.
but then, I guess interest was really sparked. My little grade school, when I was in sixth or seventh grade, I think it was, opened up a library, their first library in an old house. And, all of us students went over to look at the books, were excited. And of course, I stumbled upon the trilogy. You know what I'm talking about, Bruce Catton. And that got me hooked. So that started just, hundreds and hundreds of books and magazines later. And then, the first time I started writing about the Civil War, I was still a practicing attorney and reading all these magazines and thinking, I should try my hand. But what should I write on? And then I ran across, in a used bookstore, the court transcript, the entire court transcript of the Fitz John Porter trial. And I'm a lawyer at the time. And one of my roles was to take court transcripts and analyze them, come up with points for appeal. And I thought, well, let me meld my interest in the Civil War with what I do for a living. And that was my first article many, many years ago in the old Columbiad, quarterly journal of the war between the states. That's how long ago it was.
Oh, wow. Yeah.
So, that's the origin story, a step-by-step origin story, I suppose.
So now, why is it you decided to become an attorney as opposed to following that dream like your father had of wanting to be a historian someday?
Well, that's a step by step too. Sorry, turn this off. Um, it was a step by step. Originally, I was interested in becoming a history teacher, but gradually, as I'm in college, I'm learning more about, well, you have to take teaching courses, which I really wasn't interested in doing. And then people are saying, well, you argue a lot. You should really be a lawyer. And I kind of, I'll take the test, did well, and all of a sudden I decided, okay, this law sounds pretty good. So I kind of backed into it, and
Yeah.
for 36 years. In retrospect, it was a good decision. It's a worthy profession.
Yeah. And now one of the things that you really concentrate on is that intersection between Civil War history and the law. You've got a great interest in legal history as it relates to the Civil War. It's a kind of a niche area for a lot of people. How did you find that as that intersection? Uh,
I love to write. And, when I was practicing, I would write articles all the time on legal issues, but I'm always reading about the Civil War. And I guess it's you write what you know. And I'm spending so much time on the law that as an escape from the depositions and their, the boring stuff, I thought, well, let me apply, the law to the Civil War. And one of my first articles, well, after the Porter one, I wrote for the American Bar Association, one of their journals, an article on how the Civil War still affects the law. And so it's fun. And again, you write what you know.
Yeah.
And I know to a certain extent, I know the law, and it's just fun finding new ways how the law impacts my true love, the Civil War. So
Well, and I think you've really brought some really neat, insightful pieces to the blog as you've discussed legal issues, and it's just to me very illuminating to be looking at some of these issues from an angle that most of us probably haven't thought of, but have real deep connection to law and essentially the philosophy of what's going on with the war.
absolutely, Fitz John Porter would agree, having been cashiered as a result of a legal court martial. But yeah, there's a lot of issues that came out from the war. I guess one of the first ones was the United States captures Confederate privateers. And the Lincoln administration's legal view is they're pirates. We're going to hang them. And that becomes obviously a major point of dispute with the Confederacy that threatens retaliation. But that's the first thing the Lincoln administration is thinking of. According to international law, these fellows are pirates and they should be hanged. And legal issues continued throughout the war. The Emancipation Proclamation, was it legal? The Lieber Code that most people don't know about, the first government issued a set of rules for making war. It's the predecessor to the Geneva Convention. All these things come out of our Civil War. It's fascinating stuff.
Now, you mentioned Lincoln a second ago, and people kind of look at him as a great politician, great presidential figure. He had a really keen legal mind, and people sort of think of him as kind of this country lawyer from out west, but he was sharp as a lawyer.
He was sharp as a lawyer. And yes, you're right. I mean, the stereotype of him is this country bumpkin. Well, I reckon this and that. And the premise is most of his clients are country folk. No, he made a lot of money representing railroads. He was a highly successful, sophisticated lawyer. But that's not the narrative that we've come to learn about. But no, he was a very good lawyer, and in fact, it, he was after he won re-election. He's got 4 years to go, but he's talking to his wife about what he'd like to do, and he expects he's going to go back to practicing law.
So that's in many ways a narrative that he himself cultivated, the rail splitter, log cabin stuff. But I almost feel like underneath it, he's wearing a t-shirt that says, "Go ahead, underestimate me," like, cause he's creating this veneer of being the country bumpkin so that people do underestimate him. And then he like just bing, bing, bing.
Absolutely. You called to mind, I don't remember who came up with the quote, but one of his friends said something to the effect, yes, Lincoln comes across that way, but if you underestimate him, you'll wake up in a ditch. I think that was Herndon who said that. But you're right. Yeah, people always underestimated him.
So, who else would you consider to be some of the top legal figures of the Civil War era?
Top legal figures. Well, certainly Francis Lieber, he's the primary drafter of what we call the Lieber Code, the rules of war. Chase was a lawyer. Although he was Lincoln's Treasury Secretary, he had an extensive background in representing escaped enslaved people.
It's funny.
Lawyers, as lawyers, I'm having a little bit
Okay.
of trouble.
Well, it's because like Lieber wouldn't even have been someone that would have jumped immediately to my mind. But of course, it's like, wow, yes, of course. I think my list would have started with Stanton, who wasn't a lawyer in his capacity as Secretary of War, but he certainly used those legal skills and that legal mind.
That's true. A lot
Yeah,
of lawyers in the war. I think Seward was a lawyer,
yeah, yeah, yeah,
correctly.
yeah,
So yeah, Lincoln administration staff with lawyers, for better or
yeah.
for worse.
Yeah, William Bates, the Attorney General, I guess. But again, of the stars in Lincoln's cabinet, he's not one that kind of jumps out as one of our foremost people that comes to the tip of our tongues. So,
Sure.
um, so let me back up to Fitz John Porter, since you sort of, that was your first writing piece. You've done some writing about him for us. Um, what was it about that case that caught your interest and has been a story that has stuck with you for a while?
Well, originally, I mean, I knew who he was, and I was aware of his court martial generally, but initially I approached the project simply as a lawyer. I'm, I'm not even sure I considered him the fictional client. I'm looking at the court transcript, and I'm just going to analyze it, objectively analyze it. But as I got into it, um, I'm like, wow, this guy really got railroaded. And as a lawyer, I'm looking at this as, how can the court do this with a straight face? And I wrote the first article. But the first article was really, when you're a lawyer and you're given a court transcript um, for appeal, you are restricted to the record. So that was my approach. I did read John Hennessy's Return to Bull Run to get some context on the battle that led to his court martial. But after doing that initial article years ago, I became interested in Porter and the context. And that's when I started reading more about Porter, more about the background. Why was he railroaded? William Marvell's great book, Radical Sacrifice, goes into not only Porter's biography, but it really gets into, well, why were they targeting Porter? And part of the reason was he's a protege of McClellan, and McClellan is on the radical Republicans' hit list in the summer of '62. He's a little too powerful to take on, but we can get his buddy. And you see how Stanton is packing the court with fellow radicals, with his friends and affiliates, and with people who had grudges against Porter. And it's a stacked deck. And so it's not surprising. It was simply fascinating to keep going back to the Porter trial and looking at it and just, you know, gritting my teeth. If he were my lawyer, I'd go to bat for that guy. I'm not saying he was the best general of the war, but people forget that by the summer of '62, he was one of the leading Union combat generals.
Yeah.
He's the only general who could say, forces under my command have beaten Robert E. Lee twice at Malvern Hill and at Beaver Dam Creek. He's the only one. So he was a tremendously important figure in that and in other respects. And yet he ran afoul of the wrong politicians, and he gets booted from the army.
I think his case also illustrates an interesting point that there's military law and there's civil law.
Right.
And criminal law, but like the judicial system is separate than the military judicial system. Explain those differences to us.
Well, there's two types of military law that's practiced during the war in terms of trials. Civilians are brought before commissions. And I'm a little foggy on what rules they applied, but you wouldn't necessarily have a lawyer. Your due process rights are not very great. Military folks go before court martials, and there are rules, supposed to be rules, and you are allowed to have representation, although typically you're expected to question your own witnesses. Porter got special permission to use trained counsel. But The interesting thing, and this is another legal issue that came out of the war, at the end of the war, Lincoln unfortunately is assassinated, and the Lincoln conspirators are tried by military commission because, again, they're civilians, but they're tried by a board of officers, and they are, I believe, all of them, 7 of them or so, are convicted, and several of them are hanged rather quickly. And but again, this is the result of the war. A few months later, another civilian who has also been tried by military commission and has been sentenced to hang, he has time to get his case to the Supreme Court. And the Supreme Court, in a famous decision, says, no, under the Constitution, when the civil courts are in operation, you cannot try civilians by military commission. And this fellow, he just, timing is everything. He got his case to the Supreme Court, and Mary Surratt and the other Lincoln conspirators, for whatever reason, never met. They were hanged before they had an opportunity to get to the Supreme Court. So there's an illustration of how the Civil War affected the law. In fact, that this case, I think it was called Ex parte Mulligan, was cited by the modern Supreme Court when it was examining the procedures used by the military in the Gitmo trials. So
Oh, okay.
don't tell me that the Civil War doesn't impact the law today.
I think about William T. Sherman tried to court-martial a journalist that he didn't like, and people like, you can court-martial a civilian.
Come on, just put him backwards on a mule like me did, and run him out.
So I want to toss some legal issues at you because I'm completely a novice at this. So I'm going to lean on your expertise as a legal historian and Civil War historian here. And you tell me like your impression of how important were these things? What sort of impact did they have? What ripples did they create? I don't have any gotcha questions here because I'm having to pick big obvious things off my list. Let me back up to the Dred Scott case, which I think is one of those dominoes that becomes one of the causes of the war. How would you characterize the importance of the Dred Scott case?
It's such a bad case. It's critical legally. I mean, it's certainly important politically. It's a bombshell. It inflames tensions in the North. But what it did is to say that African Americans cannot be citizens. They have no rights at all. And so it required subsequent legislation, subsequent constitutional amendments to wipe out that case. It also, as you know, said that Congress can't regulate slavery. It can't forbid slavery in the territories. So it had a major impact on politics. Now the Republican Party supposedly can't exclude slavery from the territories. And Lincoln, he made it clear he was not going to abide by that decision. So it had legal impact for what it said, and it had a tremendous political impact on the country and made things worse.
And Roger B. Taney takes a lot of flack because he wrote that decision, but it does take a majority of jurists to get to that final decision. Everyone sort of forgets about the fact that it was a majority decision and the
Absolutely.
Supreme Court supported that. Do you have any opinion on Taney as a jurist, just in general?
He certainly was result oriented.
Yeah.
He came from his legal background was impressive. He was a former U.S. attorney, I think under Jackson. He was around a long time. But the ironic thing is he had such a long career, and other than Dred Scott, I can't think, and one other matter I'll mention in a second, I can't think of another decision that he authored that mattered. And I'm sure there are some. It's just, like you said, Dred Scott just is the black cloud over the fellow's legacy. The only other judicial action, it was not an opinion of the full court, but he's the justice that when early in the war, when a Maryland civilian was arrested for being involved in burning bridges to cut the capital off from the north and reinforcements. One of the civilians was arrested and thrown in military prison, and Taney issued a writ of habeas corpus, that is, produce the body, um, presumably to free this fellow. And the military, acting under Lincoln's authority, basically said, "We have your writ. Thank you very much." That's it.
So that was going to be one of the other items on my list. So Lincoln suspends habeas corpus. How big of a deal was that?
That's a huge deal because the question is it constitutional? I mean, he does it. Um, so it goes through. But the Constitution does provide for the suspension of the writ of habeas corpus. And for those non-lawyers who are not aware of it, habeas corpus is called the great writ. And as a practical matter, judges issue it to force the government or some government authority to produce the defendant and to justify his continued imprisonment. So that's habeas corpus. Habeas corpus can be suspended, the Constitution says, but the provision that talks about suspension is in the article of our Constitution that only addresses Congress's powers and restrictions. It's not in the article that deals with the executive branch, the presidency. So one of the major arguments against Lincoln's action was only Congress can suspend the writ of habeas corpus. Now, the way he got around that, I mean, he did it. He just did it and got away with it. The way he got around any possible trouble is when Congress was called into session, they retroactively ratified everything he did. So it never came to a head. But Lincoln, throughout the war, he would periodically suspend the writ, often to stop organized efforts to stop the draft. And I'm not sure if that issue has ever been decided, and hopefully we'll never get to a situation where another president does it. But I don't think that legal issue has ever been decided whether Lincoln's action was constitutional.
And that's a big question because like he's suspending constitutional protections as a war measure, basically to like preserve the Union. But how far can you go to preserve the Union by suspending these protections that you then stop being the country you're trying to protect, which is a big, big conceptual question.
That's a big deal. Lincoln addressed that. I mean, Lincoln had a way with words, and I can't quote him exactly, but he said in the crisis, um, all of the laws of the country and of the Constitution are going unenforced in a portion of the country. And do you expect me to allow that to go unresolved by saying I can't? He didn't put it this way. Are you telling me I can't ignore one provision of the Constitution in an effort to remedy the ignoring of the rest of the Constitution? In other words, just give me this one. I'll just give me this right to suspend the writ so that I can go down there and defend the rest of the Constitution. I'm saying it badly, but he was much better at words, as you know.
So, and it was again something he's thinking through, though.
Yes.
He's understanding all that. I think that also really speaks to his decision to really push the passage of the 13th Amendment, where, he had issued the Emancipation Proclamation as a war power, but once the war is over, he doesn't have that power. So how can he make sure that he does address that big question? And the 13th Amendment is his answer.
You're right, because I think you're right. He was very concerned that once the war is over, the Emancipation Proclamation will be a dead letter. It may even be struck down as unconstitutional. So yes, the 13th Amendment was critical to secure freedom for the enslaved people.
Yeah, I love the way he's it's like he's playing 3 or 4 dimensional chess, because he's thinking on very tactical levels, but also in very big conceptual, philosophical, strategical sorts of levels too. So let me go back to my list here. So habeas corpus. So let me back up. If I'm going to try to tackle my little list here chronologically, the legality of secession.
Ah,
Big legal question.
that is a big legal question. Um, the traditional two sides are this. The pro-secession crowd says that the Constitution is a compact of states, meaning it's like a contract. The different parties enter into it, and then if one side breaches the contract, doesn't follow through on its obligations, then each party, the states, can withdraw. And the southern states, their complaint was you are interfering with slavery. Slavery is protected by the Constitution. You are luring our enslaved people north. You're not enforcing the fugitive slave law. You have broken the contract. So we get to leave. And that is the traditional pro-secession argument. And, if you look at the historical documents and the statements of the founders of the Constitution, there is some argument to be made for that. I think the better argument is that the the nation created by the Constitution was created by we the people, that we become a nation, and that individual states do not have the right to secede. And I actually wrote on this recently. And one of the ways you do contract analysis is to see what people at the time of the formation of the contract are saying about it. And if you look at the speeches by the people who are opposed to the Constitution being adopted, they're warning up and down that this is forming a new political body. Patrick Henry, for example, was vehemently against the Constitution. He says the preamble itself says we the people. It's creating a unit, a national government, and that's evidence that the secession side is wrong. That the people who are voting on ratifying the contract, they knew what they were doing. And this compact theory was really pushed by the southern states later. So my southern friends won't like this, but I come down again on the anti-secession side of the legal analysis. But,
And that
but
was
if
something.
I but if frankly as a lawyer, if I were hired by the Southerners, I'd make an argument for them too.
Well, and there was something that eventually makes its way to the Supreme Court after the war. And the court basically says the issue was settled by the war. And
Yeah,
so it's sort of like the legal question wasn't necessarily settled, but from a practical perspective, it was settled.
right. That was Chase, I believe, and there's no way the Supreme Court is going to say after 750,000 deaths and all the treasure sacrificed. Well, the South is right. That's just not going to happen.
You mentioned Chase. Interesting figure, starts out as a Treasury Secretary just because, that team of rivals perspective where Lincoln needs to find a place for him. And he's still a pretty big thorn in Lincoln's side. And then Lincoln tries to solve that by making him Chief Justice of the Supreme Court. What did you think of that move?
Kick him upstairs. It was brilliant.
Yeah.
Take him out of politics and put him in a black robe. Brilliant. And also, he's a very smart lawyer. He's an abolitionist. If the Emancipation Proclamation gets to the Supreme Court, Chase will be leading it. So it was a smart political move. It was a smart legal move. Ironically, uh, the man who benefited the most from Chase's appointment, you might not be able to guess, was Jefferson Davis,
Oh yeah.
because despite Chase being on the court, the president he still hoped to be president one day, and he ends up part of the two judges who are going to try Jefferson Davis for treason. And when you read the history, he did not like being in that position because it's a no-lose position. If his court convicts Davis, then the South is never going to vote for him. But if he somehow lets him free, the North is never going to vote for him. So he actually um, comes up with a legal theory as to why Davis's indictment should be quashed, that basically he's already been punished enough by a provision of the Constitution that was passed. And he actually tips off Davis's defense lawyers and says, I'm just talking here. This sounds like a pretty good argument to me. And they get the hint and they make the argument. And Chase says, "Oh, what a great argument." and and he votes to quash the indictment. He has a fellow judge who says that's crazy, but now you have a split and it's going to the Supreme Court, and who knows what's going to happen. And Andrew Johnson at that point, he's had enough, and he ends up issuing blanket pardons for all Confederates anyway. But I think there was a real fear of what is the court going to do with Jefferson Davis, sparked by Chase's trickery.
Based on his own political aspirations, not even necessarily a
Absolutely.
legal thing. So yeah, it's and the question of what to do with ex-Confederates is a huge legal issue, and Grant, of course, maintains the idea that he gave them paroles, and so we need to honor them from a military perspective. But that's different than the legal issues and the political issues that are involved with that.
Absolutely. Robert E. Lee, well, Davis, of course, was indicted. Robert E. Lee was indicted for treason shortly after the war, and he's at real risk. And as you pointed out, Grant's view was that the surrender terms at Appomattox, one of the terms was you will give your paroles, and the government won't bother you as long as you're not bothering anybody else. And Lee actually wrote to Grant and said, I've been indicted. I thought that we dealt with this at Appomattox. And Grant agreed, and he went to Johnson and said, no, you can't push this indictment. And according to Grant, he said, and if you do, I will resign, which would have been a political, public relations disaster for Johnson.
Right, right.
But yeah, there's definitely a question of what do you do with all these rebels? Do you hang them, or what do you do? As you probably know, the only the only ex-Confederate who did go through a trial and was hanged was Wirtz, the commandant of Andersonville prison, but that was less than the fact that he was a Confederate. It was more for what happened at Andersonville and vengeance.
Right.
But ultimately, Johnson takes vengeance off the table with his blanket pardon at the end of 68.
So his impeachment, another huge legal issue that relates to the war, sets some precedents. We've seen impeachment since then, and people have leaned back on the precedents. And they remain impeachment remains a controversial mechanism today because of those precedents that were set by Johnson's. Walk me through some of those legal considerations, just in a brief sort of way.
Sure. There had never been, before Johnson, excuse me, there had never been an impeachment of a president. There had been impeachments, I believe, of judges, but never of a president. So you're right. They're making it up as they go along. The issue that he was impeached over, technically, was Congress had passed a law preventing the president from firing his cabinet officials because they were trying to protect Stanton. and he fires him anyway. And that's the technical reason they give for impeaching him. But we know it was politics. It was the radical Republicans trying to remove an obstacle to their version of Reconstruction. And as you say, the procedures that were used, that are being or have been used recently in impeachments, really were created by the Johnson impeachment. How do you do the trial? Who presides? What procedures are you going to follow? All came out of the Civil War, or shortly after the Civil War and the Johnson impeachment. Another legacy of the war, legal legacy of the war.
So, the big one that I haven't really mentioned, we've danced around it, but I haven't just asked about the Emancipation Proclamation, which to me is one of the most important legal moments of the Civil War. I don't know if you agree with that assessment, but how would you rate the Emancipation Proclamation and its impact?
Well, legally, it had a huge impact, certainly. I know people say, well, Lincoln only freed the slaves where he couldn't, and he didn't free them where he could. But it still had a huge impact as Union armies advanced. But legally, it raised a very serious issue, which we've touched on, and even Lincoln was concerned that it wasn't legal, um, because the Constitution has a provision that says that you cannot you can't punish descendants, basically. In merry old England, if you were accused of treason, you'd lose your lands and your whole family would lose their livelihoods. The Emancipation Proclamation was attacked because Lincoln's taking away property as a war measure, but he's taking it away not only from the current slaveholders, but from their families. So again, it's their descendants. It's a legal issue. Um, and Lincoln knew that even when he issued his, I think it was December of 63, he issues a proclamation urging Southerners to come back to the Union, accept a pardon. And a provision in his proclamation is one of the things you have to do to come back is to accept the Emancipation Proclamation. And then he writes, unless it is struck down by the courts.
Yeah.
So he knows that it's a real serious legal issue. And again, the legacy of the Civil War. The Emancipation Proclamation was the subject of a court case in the Supreme Court case in the 1950s. During the Korean War, Harry S. Truman intervened in a strike in the steelmaking industry. And he had the government take over the steel mills because we're in the Korean War and we need the steel. And the Supreme Court, and he cites presidential war powers and the Emancipation Proclamation. And the Supreme Court says no. I haven't looked at that case in depth, but that's another possible topic. Again, the impact of the Civil War on today's law.
That might be a good way for us to wrap up here, because you talked early on about, these ripples that still exist from the legal history of the Civil War. What invitation might you give to our listeners and our readers about finding out more about that and the way that the Civil War, from a legal perspective, still impacts us today?
That is a good question, and you may have me stumped. I think I would just say read whatever you're reading about the Civil War, but with an eye open to legal issues. Don't just assume that the war was fought on the battlefield. And if you look with an open eye, you will start to see legal issues popping up, and that can lead to further inquiry and some interesting finds. And you don't have to be a lawyer to do that.
That was a great answer. You're like, you might have me stumped. Yeah, it was a great answer. Of course, my answer would be read Kevin's posts at Emerging Civil War, because he'll have have lots of good
Well,
stuff.
well, that goes without saying.
But I do think, like you raised this really great point, though, that we sort of have a way of approaching our studies to the Civil War, and we have to kind of open up our lenses to look at these other areas that are there. We're just maybe not seeing them. We're used to seeing them through those lenses.
Exactly. We don't think about them, but they're there, and they're there in plain sight.
Yeah, yeah. So this has been a fascinating conversation. Now I want to go and kind of peel some things open and look at the little list of bullet points I came up with and dive into them in greater detail. Kevin, this has been a lot of fun. I appreciate it.
It's been fun. I appreciate the opportunity, and I'll say again, as I've said privately, I am both thrilled and honored to be part of emerging Civil War, and I hope I will continue, or I hope I will contribute as a recovering lawyer.
Well, we're thrilled and honored to have you with us. Thanks so much.
Thank
I'm
you.
Chris Bukowski for Kevin Donovan, the Emerging Civil War podcast. Thanks for being with us. We'll see you online and on the battlefield.